Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who've been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning in to the For Better or Worse or Divorce podcast, where we provide you tips and insights on how to navigate divorce and child custody situations. I'm Brian Walters. Today, I'm joined by Leigh Baseheart Kahn. She's a partner at Schwartz, Sladkus, and some other names, which is based out of New York City and also in South Florida, and does family law. Leigh's been practicing law for over 20 years and has worked on all aspects of matrimonial matters, from the preparation of complex prenuptial and marital settlement agreements to the preparation of matrimonial matters for trial. Today, we're going to be discussing some complexities and issues around child custody, specifically 50-50 custody, a topic that we discuss with potential new clients calling the firm pretty regularly and are excited to have Leigh to join us with her expertise. So, Leigh, give us a little more background about yourself. I always tell lawyers, don't give me the law review, bio. Tell me something interesting, like where were you born, and anything interesting that you do in your life other than be a lawyer, that kind of stuff.
Good morning, Brian. Thank you for having me. I won't give you the normal law school bio. What I will say is, I work in New York City. Lived here for 7 years, but as soon as I was going to have children, I got out. So I live in northern Westchester.
Yep.
Have 2 kids. One is in college at the University of Michigan. And I realized when she decided to go there that everybody knows someone who has gone to Michigan. So go Blue. And I have a son who's a senior in high school now and going through the application process, which is so fun.
Yeah, about to get them both out of the house, it sounds like. So
I am. I'm on the cusp of being an empty nester.
My wife and I have 2 kids, and ours are younger, but she talks about that a lot, about, that's like a bittersweet moment, right? I mean, you want them to go on in life and prosper, but you also miss them. At least most kids, maybe not every one of them, and maybe not every child misses every parent. But that's interesting. And so you guys have an office in South Florida, Miami, greater Miami area, I assume, as well. Is that correct?
Our South Florida office is in Boca Raton.
Okay. Mm-hmm.
And we do have matrimonial lawyers there as well as up here in New York. If
we're all over the state of Texas. If we ever went to another state, I think probably Florida would be the first choice to do that. And we've actually looked into it a little bit here and there, but have never actually pulled the trigger on it. But that seems to be the fastest growing area and a center of a lot of things these days. So
it does. And sadly, I've never found an excuse to have to visit the Florida office. But, hope springs eternal.
Well, no state income tax. That might be some reason to think about things in a longer term. That's certainly a selling point. That's why we get a lot of people coming to Texas too. So, okay, well, let's talk about the subject at hand. So I get this all the time in calls on intakes or even for existing clients. And so about 50-50 custody, which, can mean a lot of different things to different people. But I'll lay out what Texas does with custody and child support and that type of thing. And you can kind of tell me what New York and to the extent Florida does. But for here, we don't have a 50-50 as a default. It's what's called a standard possession order. For the court kind of picks a custodial parent and primary parent, and then everything sort of flows from that. In most cases, there's a bunch of presumptions, which means that's what the court normally does. And that's what most people settle on eventually, which is how most cases are resolved. And in Texas, that looks like the primary parent has a majority of the time, but it's not a big majority. It's somewhere between 55 and 60%, depending on the exact terms of it. It's intended for both parents to live nearby, but there to be kind of a main home during the school week is sort of the concept. And then the non-custodial parent gets probably a majority of the time, of the free time, the weekends and the holidays and the summer and that type of thing. That's sort of the structure that we have. And from that flows child support. We have a very simple, I don't know if it's how fair it is, but it's simple. That's its own plus, I guess. Method of calculating child support, which is basically the non-custodial parent pays a percentage of their post-tax income, 20% for one kid, 25% for two, to the custodial parent, pretty much regardless of their incomes and the difference in their incomes. In theory, the court can consider that, but in general, they don't. I think, again, we think we prize predictability here a lot, which makes it easy to settle because everybody kind of knows what's going to happen. So that's the way we do it here. We don't, you rarely see a 50-50 custody arrangement either by a court or in a settlement agreement, but it can happen. But it's pretty rare. It's kind of disfavored under the law. So how by contrast, does New York handle things, or is it similar to that?
New York doesn't have any presumptions at the moment, and I'll get to that in a second.
California is the same way, which boggles my mind. I don't understand that, but that's the way they do it.
For custody, it's the best interest of the child that is the overarching standard. There's no presumption there's legal custody, which is decision making, and then there's physical custody, as you know, which is where the child lives. There's no presumption as to either. I will say most of our cases end up with joint legal custody. We may have guardrails in there to help people if they may have difficulty making joint decisions, like going to consulting with an expert in the area or a parent coordinator who's someone who stays on retainer and helps them. As far as physical custody goes, that's the one that's gotten trickier in recent years. As I said, there's no presumption in New York State. There is a law, a bill pending in our state legislature to put in place a presumption for temporary custody of equal parenting time, a rebuttable presumption. That's still in the state legislature. It hasn't passed. But it's only for temporary, not for permanent custody. For permanent custody, again, we have no presumption, but the trend has been that, either by settlement or in the courts, I have found there has been a trend toward ending up at some point at 50-50. With younger children, not necessarily there may be a step up to that, although I have had cases recently where children as young as 4, 5, 6 have an equal parenting schedule. So it's becoming more common. It is by no means what happens in every case. And, I can't even say this is necessarily the norm across the state because New York's a big state. In New York City, we have 4 appellate departments and each one may do things differently. But I have found recently that it's sort of skewing in that direction, which carries with it its own host of concerns and potential problems.
Yeah, absolutely. And you read about this all the time about, some state legislatures filed a bill wanting, 50-50 time or whatever the case is. And I think people read that on the internet and think, oh my gosh, they conflate somebody, I think there's almost 10,000 state legislators in this country. And there's hundreds of thousands of bills filed every year, and just one legislator filing one bill in, Minnesota or Texas or New York doesn't really mean anything. It's a question of what becomes law, which is a much, much smaller number of such things, especially when there's a big change like this. So it'll be interesting to see. My guess is that once at least a major state actually makes that the presumption of 50-50 up front on a final, especially, I suspect it'd be a little bit like a dam breaking. I think a lot of other states will start considering that. So we'll see. And I'll say one other thing about Texas is that under the age of 3, there is no presumption, which does make it more difficult sometimes to come up with an arrangement for really young children. So that standard possession presumption is only for 3 and out.
Right. And in preparation for this podcast, I was looking around someone to see if there were some states that do have a rebuttable presumption already. And apparently some do. I gather Arkansas does, Kentucky does, Missouri passed one last year, with varying levels of what the standard is to overcome that presumption.
Right.
And I gather more state legislatures have bills pending. So it is starting to become more of a consideration. I'm actually a fellow of an organization called the American Academy of Matrimonial Lawyers. We're a national organization with about 1,400 lawyers from across the nation. And we actually passed a couple of years ago a resolution in opposition to there being a presumption of equality of shared physical custody for a whole host of reasons. Because presumptions, for instance, don't consider a number of factors that courts normally consider in determining what's in the best interest of the kids. Whether there's domestic violence, whether there are, what the differences are in how the parents have a relationship with their children, the relationship with each other, how close in proximity they are to each other, what a child's mental health or psychological needs may be, the age of the child and the child's preferences, and when there's a presumption, those factors may get lost in a determination. So it was a concern enough of our organization that we put out a resolution on this issue.
Yeah, understandably. And I get that a lot when people come into my office and, why wouldn't it be 50-50? I'm just as much of a parent as the other one is. I love my children just as much. I'm just as capable. And it's a fair question. I totally think that it is. But let's go through some of the reasons that are cited. And again, that's the law in Texas. So obviously the state legislature and the governor so far have thought that these reasons override a 50-50. I mean, the first one that comes to my mind is exactly the way it's structured, is the school schedule, is that to be a 50-50 time, let's just say that's week on, week off. And let's just say it's a fifth grader or something like that. To do that, realistically, you would both have to live, it's an elementary school, right? So you'd have to both live pretty close to the school, I think, because if they're going to get on a bus, they'd have to both be in the bus route, right? They'd both have to live within the area of the elementary school. And in a large city, that's a small area. Where there's a lot of population, there's a lot of elementary schools, and you might, if you live 3 blocks away, you might be in another elementary, so the bus isn't going to come there. Or if you live 10 miles away in a dense area, that might be a 30-minute drive each way, depending on traffic, et cetera. And so now you've got a kid who otherwise, if they were kind of in the primary home arrangement during the school week, that could either walk to school or ride a short bus ride or have a 2-minute car ride. Now they're looking at, when they're at the other home, if they're not close by each other, they're spending an hour a day on the road. That interferes with everybody's schedules. That can be a problem with schoolwork and homework. And if a parent has to stay at work till 5 or 6, now the child, instead of being able to come home right after school, has got to stick around with aftercare till 6 o'clock or 6:30 or something. You can come up with a lot of reasons why that would be an issue. And I think most parents probably, when they get divorced or split up if they're not married, probably think they're going to live pretty close by each other. But the reality is that's if you get divorced when your kid is 6 years old, it's unlikely you're going to live within 3 or 5 miles of each other for 12 years till that kid graduates from school. And so how do we deal with that? I think that's, to me, kind of a logistical issue around school to me and the related extracurricular activities that are often school-based. To me, that's one of the main arguments against it, just a regular 50-50, is it wouldn't be practical at some point. So anyway, what are your thoughts about that?
Well, I think also, I think that's right. And I think what it also highlights is the need for good parental communication and co-parenting. If you're going to have a 50-50 schedule, even if it's, week on, week off, or some other variation of that, you have to have parents who can get along, who can coordinate. What if, for example, the child leaves a book or something for an extracurricular that they need at the other parent's house? You've got to have a willingness to communicate and, have an exchange with the other parent. You have to be willing to have, for example, be on the same page for discipline and house rules and bedtime and all sorts of things. Because if in an equal parenting schedule, one house has one set of rules and the other one has a very, very different set of rules, not only does it make it difficult for the parents, it makes it difficult for the child to adjust half the time to one set of rules and half the time another. So you have to have parents who are willing to be on the same page with each other. And there are some who can. I have some clients who say, look, I can accommodate, I can go with the flow, this is what's best for my kids, and that's great. But you have a good number of situations where that's not the case. And for whom an exactly equal schedule would be difficult for the logistical reasons.
Yeah, no, I agree. I think that's a good summary of it. And again, I think when you start out, when you first split up or divorce, it's not that difficult to do that 50-50. But what happens 3 or 5 years down the line when somebody has to move away, to a different part of town, they remarry, get a job, different job, that kind of thing. Now how do we deal with that at that point? I think that's a problem. I mean, for example, in Texas, under the standard possession order, there are 3 different versions of it. There's the one where you live real close to each other. There's the one where you live kind of in the same general area. And then there's the one where you live far away from each other. And you actually have 3 possession orders when you do that. And it just depends on how far away the parents live from each other. Usually the main parent or the primary parent is restricted to a specific area. And so that can, how are we going to do that if it's 50-50 and now somebody moves? Do we have to come back to court? I think that you often would at that point. Well, I'm moving, I don't have a choice, and why should I be penalized, right? And now you have a custody battle number 2, 3 years later. And I think that's one of the reasons that courts, at least in Texas, are trying to avoid that arrangement. And I can see why New York would have potentially on temporary orders of 50-50, because usually, you're just splitting up, you're generally staying in the same area, and it's a lot going on, and that might kind of calm everybody down. But long term, I think you're going to have to think about some other arrangements.
I think that's right. And, and one of the other things, and I've had this concern come up in some of my cases, one of the things with particularly a presumption of equal parenting schedules is, to a certain extent, it makes it almost more about the parents than the children. And the children are supposed to be the focus of this. And an issue that I see is is the potential for using it as leverage. If a parent, wants to get an edge financially, they can say, well, we have a presumption of equal custody, but I'm willing to compromise on that if you're willing to compromise on these financial issues, for instance. Another potential problem is, at least in New York, the way our child support statute works. It's like Texas in that, the non-custodial parent pays, and there's a calculation based on percentage of income, child support to the custodial parent. But when there is equal parenting time, what our law has developed is that the parent with the greater income pays child support to the parent with lesser income. So then you have situations where, people think that there may be motivation to seek an equal parenting schedule to impact the child support award.
Right.
Our judges are aware of that. I've had one judge in a talk outside the courtroom, just speaking to a group of lawyers, mention that she knows that that's a concern and she's mindful of that. But it's something that complicates a presumption of equal custody, because then you build into it, in New York at least, that presumption of, okay, what's the motivation for fighting to keep the presumption, or what's the motivation for seeking to rebut the presumption?
Absolutely. And I do think there's again, I typically get these folks coming in, sort of from the, I read somewhere, which, might be reliable, it might not be, but I do get the sense that there is some of that where, if I get 50-50, I don't have to pay child support, or I get a big discount. And again, I think that's one of the reasons Texas doesn't presume that, because they want this to be real predictable, so that everybody settles their cases, or almost everybody settles their cases and doesn't clog the courts. And I flushed that out usually pretty quickly by saying, okay, well, if it got you 50-50 time, would you still pay the full amount of child support like you just had the standard order? And if the answer is just an unequivocal, sure, no problem, I don't care, I just want more time with my kid, well, then that's probably what driving it is more. But I often don't get that response. I usually I thought I wouldn't have to pay child support in that circumstance. And then, and I think the judges are real sensitive to that. I had a trial recently where we took exactly that position on custody for the dad, even in his higher wage earner, but if I win or lose custody, I don't care. I'm still going to pay the standard amount of child support. which took that issue off the table, I think, of them trying to say that's what was driving it. And I think won him, a good amount of points with the jury and judge in that particular case. So, I think that is something people ought to be aware of, is that if you do truly want more time, that probably won't affect your child support payment. So think carefully about what that is. The other part of this is that busy parents, who are most parents, whether they have a job or whether they're a stay-at-home parent or whatever, they often can't even use all the time that they're given, especially if they've remarried or had another child with somebody, or remarried and had another child with somebody. Most schools, at least in Texas, get out around 2:30 or 3, right? And most people have to work past that time. Most adults do. And so can you really, use that after school time every day? Can you really, use all of the 30 days in the summer we have in Texas for, it's kind of intended to be sort of a long vacation. Most people can't take 30 days vacation, and they end up, actually, it becomes a problem in the summer. Like, what am I going to do with my child? I've got to work, and they're with me for 30 days. And sure, we can go in a week to Disney World or whatever, but what about the other 3 weeks? And so these can be problems. And so sort of one of those be careful what you ask for situations, I think.
Right. And I've had that come up recently since the pandemic, with more people working from home.
Right.
And so they say, well, I work from home, so I can have half the time because I'm still home. But when you have very young children working from home, I've worked from home with very young children. And it's not as easy as it sounds.
No. I mean, me too. I do that all the time, but I have to close the door, and, my wife and kids know not to bug me.
But if you're a single parent who has a child with you for 50% of the time, you don't have that luxury.
Absolutely. And, all that it really does is cut down on your commute time, which, maybe that's a big amount of time. Maybe that's not. Maybe you can work, after take 2 hours off in the afternoon to be with your kids after school or whatever, and then pick it up at 8:00 at night. But again, I don't think that's very practical for most people. They're probably going to want to do something else with their time. So, I think, again, in theory, I think this makes a lot of sense. Both parents love their children. Both parents want to be with their kids as much as they can. But at least in Texas, and it sounds like New York as well, at least on a permanent order, we're not going to typically see 50-50s here. And maybe the law will change at some point. But I haven't heard a real push for that. We've actually got a couple of family lawyers that are in the state legislature, and they kind of keep us informed about what's happening and not happening. And basically, there's not much change. I took 5 years off to kind of in the middle of my career to run and own a different business and just kind of take a break from this. And I came back after 5 years, and literally nothing had changed. So, although that's not true. Same-sex marriage had become legal, and but that really didn't change anything either. It just was like, okay, there's a few more people,
right,
a few more clients, but otherwise there's no difference. It didn't change anything. Like the law didn't change the financial stuff. It didn't change custody issues if they both, if they had a child together, whatever. It was nothing literally had changed. So maybe there'll be some big changes in the future in Texas, but I don't anticipate it anytime soon. We'll see. Who knows?
And in New York, it's changed over time, but the way I look at it as we're getting to a lot more 50-50 custodial arrangements, even without there being a presumption in the law. People get there, or courts award it. So the way I look at it, if we get there anyway, why do we need to put in something that creates complications that don't need to be there?
Yeah, absolutely. That's very true. Okay, well, I think that's all the time we have for today. If you're interested in reaching out to Leigh directly, we have our contact information in our bio. And thank you for joining us today, by the way.
Thank you for having me.
Yeah, my pleasure. As always, if you have any follow-up questions on this episode or would like to talk to one of us directly about your family law situation, reach out to us at podcast at waltersgilbreth.com, or you can just contact us directly through our website, waltersgilbreth.com. I'm Brian Walters, and thank you for listening.
Thank you.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreth.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreth.com. Thanks for listening. Until next time.